The following is a paid program. The advice and opinions expressed on the program are solely that of Melick Law, not necessarily WBEV or Good Karma Brands. Welcome in, everybody, to Taking Care of Business today, featuring Rob Melick with Melick Law. Rob, how you doing?
I'm doing well. How are you, sir?
Doing very, very well. It's been a little bit since we've talked, but it's always nice to get a chance to catch up with you.
You bet.
And, of course, since we've last spoken, the weather's gotten nicer. Summer is here and in full swing. People are out and about doing things, getting active, having a good time.
Trying to, at least, with these random days like today of mid-60s and rain. I guess it's a little more difficult, but
yeah,
it's peeking through. Summer's
true.
Working out as decently as it can, I guess.
The weekend was very nice, though.
Yeah,
Did you do anything fun for Father's Day?
Not really, no. I had my son had a baseball game, so we went to that. And other than that, we went to Five Guys for a Father's Day meal.
There you
that's
go.
One of my favorite places. Great burgers there. And my wife and my oldest son are in Europe right now, so it's just my younger son. And my wife has a peanut allergy, so Five Guys is off the table when she's there. So
Gotcha.
we figured she's not there. We all like peanuts and burgers and good fries, so we went to Five Guys. So
I like it. And it's always nice when you can have a really good burger and you didn't have to grill it up.
that's exactly right. And I don't know what they do to their burgers, but they are so much better than any other burger I've ever had in my life.
They are really good. And there's also something nice about just being handed like a sack of fries.
Yes.
Like, here you go.
Oh, yeah.
Nothing wrong with that. Well, of course, we always bring you on because you talk to us about a lot of things involving estate planning, end-of-life planning, because as we say every time, none of us get out of this alive. And that's a huge important part of what we do. There's that legacy planning. For many of us, we might have kids or, people that we want to leave stuff to when we move on. It can be a very morbid, dark conversation, but it also can be a very powerful conversation, a very important conversation to have. Before we dive into some of our questions, and I give you a little bit of a scenario involving my own household, remind everybody your background and why you decided to get into this law.
Sure. So I guess I'll start at the beginning. I grew up in Washington County. I grew up in Hubertus, right in the shadow of Holy Hill there. That's where I grew up. So I went to high school here, but I ended up going to college and law school out in Pennsylvania. I was getting recruited to play football at the University of Chicago. Their defensive coordinator became the head coach at Swarthmore College out near Philadelphia, and the sales pitch was pretty simple. Similar academic schools, except one is in beautiful suburban Philadelphia, the one is in one of the roughest parts of Chicago. So I chose the safer environment. So went out there, ended up going to Penn State for law school, and then moved back here in 2014. In 2016, I started my own law firm devoted exclusively toward estate planning. And really the reason I chose that was one of the jobs I had in Pennsylvania right out of law school. I worked for an attorney who did predominantly estate planning work. It was a big firm. There were a lot of attorneys who did a lot of things there, but the one who did estate planning work kind of took me under his wing a little bit. And what he explained to me was, he said, estate planning is one of the areas of law that has the lowest stress among attorneys because there's no opposing counsel, there's no court deadlines, and that really stuck with me. A lot of my day is just having conversations with people. It's learning their situation, proposing some options that might help make this inevitable event of death as easy financially as possible for their loved ones, so that it's one less thing that they have to worry about. So that's what I enjoy most about my job, is just having those one-on-one interactions or even family meetings, whatever the case is, and just kind of explaining the options, listing out pros and cons, and then hopefully having people make a decision based upon the receipt of full information. Because for whatever reason, and again, first generation lawyer here, so I don't have a lot of experience with this, but I have what I have on my job here. But I will have practiced law for 18 years in September here, so coming up on that milestone. But for whatever reason, estate planning is one of those fields that people just know very little about, and they think they know a lot about it. They see something on a movie, they see it on TikTok, and there's just a lot of inaccuracies there. Whereas other areas of the law, people are like, well, that's the lawyer. The lawyer's going to explain to me what the law is. A lot of people come in with preconceived notions about what estate planning is, how it operates, their incorrect view often that they don't need it, things like that. And so a lot of my job here, especially on shows like this, is to first and foremost provide information. I don't care. I mean, we're talking about estate planning right now, but I don't care what the field is. There's nobody who can make a fully informed, balanced decision without first receiving full information, learning about the subject at hand, or at least trusting someone who does know that area, whether it's something as simple as auto repair or home renovations, whatever the case is. There's a reason people do that professionally. There's a reason people give information and people need to obtain that information first before they make a fully informed decision. So my goal in my practice, both on this show and just generally my practice, is first and foremost to educate, to dispel some of those misconceptions and to explain to people what the reality is, what the consequences are of not having an estate plan, what the consequences are of not having powers of attorney, what the consequences are of only having a will as opposed to a trust, the consequences of having a trust drafted perhaps by an attorney who charges for revisions. There's any number of things that I need to educate prospective clients about, and if the decision is ultimately they go somewhere else or they don't get it done, fine. At least they've made a fully informed decision in conjunction with their ultimate decision there.
That makes a lot of sense. And I know you kind of touched this a little bit. It's very easy for people to, in a lot of scenarios, say like, oh, well, you need a lawyer. You were in a car accident. You should get a lawyer. Neighbor cut down your fence and it's definitely your fence. You should get a lawyer.
Right.
There was a lot of different situations where people are like, speak to a lawyer, whatever. But not everybody's thinking about a lawyer when it comes to planning for those inevitabilities.
Right, and that's kind of interesting in my mind because all those events you just listed don't happen to everybody.
Right.
They happen to some people. I mean, not everyone's going to be in a car accident that requires litigation. Not everyone's going to have a neighbor who decides to cut down some of their trees. Not everybody's going to get divorced. These are areas of law that people may or may not experience.
Right.
Well, I can tell you this, unless an immortality pill is invented, we all have, as members of the human race, a 100% chance of passing away at some point in time. These are going to be issues that everyone needs to address. So everybody out there over the age of 18 is a potential client of mine just for that reason, because this is an inevitability. Now, we're going to talk about some things like incapacity that may or may not happen, but mortality is a given. We are all going to pass away at some point. And the problem is, if we don't have a plan in place, we're never going to know what the consequences of it are, but our loved ones will. Right. The people or the causes we want to benefit will know that, because more of their money is going to be subsumed in legal fees and court costs and may not even go where they want it to go, depending on what the state laws are if somebody does pass away without a will or a trust, or if the will or trust ends up being defective. People say, well, go online. Well, I can tell you I've seen some of those online wills and trusts, and they're full of errors. They're full of things that may not make your estates go one way. I mean, I'm not going to use the name of the company, but there is one pretty prominent company that I've seen a lot of their work, and they have everything governed by the state laws of California. Well, guess what? We don't live in California.
Right. Last I checked.
It's one of those things where I don't know what they are, how they're doing it, but again, that's the reason people should retain a professional who they can see eye to eye, they can meet with, they can call at any time, as opposed to relying on an anonymous company that may or may not be around at that time, that may or may not have the documents drafted correctly, that may or may not even have the documents drafted by a lawyer in certain circumstances. So again, for whatever reason, estate planning is one of those do-it-yourself fields. I mean, there's very few people who'd get arrested of a crime and decide to represent themselves.
Right.
It usually doesn't happen.
And what's the judge always say?
The person who has, I always forget this phrase too.
Yeah.
It's the person, the attorney who has himself as a client has a fool for a client.
Yeah.
Something along those lines. And that's exactly it. I mean, you just don't know how to do it. You need to have representation, but so too you need to have representation when it comes to estate planning. Again, an event that will occur as opposed to one that might occur. So that's
we talk about how these are events that will occur, and yet a lot of times we don't think about them, or we think, oh, it's so far off in the distance, it's not something I need to worry about, I'm not concerned about it. I'll use some example for myself. Recently, I had a trip to the ER, and for those who are concerned, everything's fine, everything's great. It ultimately boiled down to I had an inner ear virus and gas, but the symptoms that were showing up felt more like a potential appendix issue, the lightheadedness and vertigo. They're saying that could be a heart issue. You're a bigger guy, so full EKG, full CT scan, full blood work, everything came back. I'm perfectly healthy. I'm just fat. So I'll take that. But before we knew anything and we're sitting in the ER, my wife is immediately going, well, what are we going to do if it is a big thing? What are we going to do if this is it for you? How am I going to take care of the kids? How am I going to pay for the house? How am I going to handle all this other stuff? And her brain was less focused on, am I going to be okay? And worrying and having anxiety over how is she going to handle things, or what is she going to do if I'm not okay? And that's a horrible mindset to be in. You want to be focused on the person that you're there with and not worried about what happens after necessarily.
Right. And again, having a plan. First of all, we're glad you're okay. So,
Me too. Me too.
Beyond that, I mean, it's one of those things where, yeah, the focus should be on that person, but oftentimes the focus isn't on that person when these other steps haven't been taken. In other words, it's easier to focus on the recovery of the loved one when your estate planning and financial stuff is already in line, because you don't have to worry about that. Those questions don't come up. Those questions are already dealt with through having a proper estate plan in place. So it happens. And you know, you talk about death and inevitability, putting it down the road. I mean, the example I always use is this, and this story gets less compelling as I get older, but it's still statistically significant, okay? My graduating high school class was 88 people. Okay. I was the class president, so one of the things I was unknowingly taxed with was doing reunions and stuff like that, right? So what I can tell you is this. I graduated high school in 1999. That was 26 years ago. Okay, I'm 43 years old. We've had 7 people in our graduating class pass away already.
Wow.
And I think the most recent one of them was at least 4 or 5 years ago. So, I mean, we're talking 7 people in a class of 88 have died before their 40th
And it's like
birthday.
10% of your class, almost 10% of your
Exactly.
class.
So, I mean, this does happen. Now, anomaly, sure. I mean, but again, that is a subsample of 88 people in which 7 have passed away.
Right.
I mean, to me, I hate using that tragedy, but it's 100% accurate. It shows that nobody's guaranteed tomorrow. And if you look at the manner of passing of all these people, you know, I mean, one had cancer, so you kind of saw it coming, but the other ones were kind of spur of the moment stuff,
Right.
you know, auto accidents, things that you can't plan for. So, you know, obviously with someone who had cancer, she had cancer for quite a while. And again, I don't know what her exact situation was, but she would have had the opportunity to plan. She would have had that opportunity. I mean, as horrible as that is to do it, you know, 25, she at least would have known. Whereas the other ones, you wake up perfectly fine one morning, the next morning, it's over.
Right.
And that does happen. And that's why estate planning is so important. And I always will say that's why it's called estate planning, not estate reacting. We need to plan. We need to have this in place. And the best part is it can change at any time. Right. Just because of your current set of circumstances now, that doesn't necessarily mean they're going to be down the road. With the estate plans that I offer at my firm, not only do you have the ability to make those changes down the road, at my firm, I don't charge for those revisions. So if somebody does an estate plan with me and those changes do occur down the road, those changes are completed on a complimentary basis, because I challenge anybody in the listening audience to turn back the clock 20 years and say, if I had done this estate plan 20 years ago, would my distribution be the same? Would the people I'd want being in charge the same? The answer is probably not. And then if you go 20 years prospectively, same thing. You know, I look at my situation. I have 2 boys who are 15 and 12. In 20 years, God willing, and them being alive, they'll be 35 and 32. Right. The situations could change dramatically. One, I hope one or both of them are doing this radio show with you as opposed to me, right? That's one thing. But even if they're not, they're probably going to be in charge of their own trust at that point. Right. Maybe I'm blessed with grandchildren at that point. Obviously, my estate plan doesn't include grandchildren yet because I don't have any grandchildren. But these are just some examples of things that would change over time. Again, my current situation, my 2 sons have one role, beneficiary. That's it. They get the money if my wife and I pass away. That is it. That is the only involvement they can have until they're at least 18. Right. But again, as life progresses, changes may and probably oftentimes should occur to those estate planning documents to bring them up to speed. I always tell my clients that an estate plan is not like a gallon of milk. It does not have a defined expiration date. Right. The only thing we need to worry about is, were there any law changes between the time the documents were drafted and now? And obviously we would need to account for that. And then the other thing is, as we discussed before, what I call preference sufficiency. Have your preferences changed between the time you did the original documents and now? And if so, we need to update those. And the one thing I find interesting in particular with older documents is, and there's a lot of attorneys who do this, it's not like I just see it through one attorney, is that we have healthcare powers of attorney. And I'll talk more at length about what a healthcare power of attorney is. But basically, a healthcare power of attorney is a document that allows you to nominate someone who can make medical decisions if you're alive but incapacitated, okay? For purposes of this statement, what I find fascinating is attorneys draft these documents without phone numbers. And it makes me scratch my head a little bit. You know, the example I give is if I'm out, whatever I'm doing, I'm out shopping one day, I'm out going for a walk, whatever the case is, and I end up having a stroke or a seizure, and my healthcare power of attorney is on file with my primary care physician, how are they going to get a hold of anybody? If the power of attorney doesn't have phone numbers on them, it's basically useless at that point. And when I boil it down to that simple level with the client, they're like, well, gee, yeah, that makes sense. So we need to update those documents to make sure, or the phone numbers will be out of date. 20 years ago, a lot of people had landlines. Besides my in-laws, I do not know anybody who has a landline anymore, right?
I don't think I do either.
Right. So, when you have the landline, that's great. But when you don't have it anymore, that landline's pretty useless. 20 years ago, it was probably the only way to get a hold of somebody.
Right.
Fewer people. I know I didn't have a cell phone 20 years ago. I mean, I had my cell phone right when I graduated law school. So it was 2007. That's when I got my first cell phone. So again, it's one of those things where at that time I would have probably listed my parents' home phone number. I don't know. Right. I mean, I remember calling home with a calling card.
Oh yeah.
My law school had a couple phones where you could just call on calling cards, and that was it. I just wasn't what we had. So just the importance of just those little things. And again, for those people in the listening audience here, if you are uncertain about the sufficiency of your documents, either go back to the attorney who drafted them, or if you'd rather work with me, you certainly can. And I can offer that free initial consultation just to give a second opinion or a look at the current documents to say, hey, are these documents still legally sufficient? Are they still preference sufficient? If so, great. If not, how do we go about updating them? And I do everything, again, as I mentioned, on a flat fee basis. I want my clients to be certain with fees. I don't want any hidden surprises or any ongoing fees, nothing like that. I tell you a flat fee, that way you have full information to decide whether you want to go forward with it or whether you don't want to go forward with it. And the only way you can possibly make a fully informed decision there is if you have a flat fee. And a lot of attorneys charge by the hour. They have X rate per hour. Well, how do we know how many hours it's going to take, right? We don't. Now, for my probate work, I do charge by the hour because there's so many variables. But when it comes to 95% of my work, which is drafting and revising existing estate plans, all of that is done on a flat fee basis.
And of course, we talked about before, you try and do everything you can to avoid probate.
That's right.
So that way you don't have to do that work.
Well, exactly. And what it is I'd say, and again, I don't keep exact stats in my office, right? But if I had to guess, maybe between 5 to 10% of my work is probate work. And usually where it comes into play is a client of mine who does a trust. They end up having a relative, a sibling, a parent, even sometimes a child, unfortunately, pass away prematurely, and they didn't have any documents in place. They didn't have, or they only had a will and they didn't have a trust in place. And now the estate's going to probate. So that's how I get the majority of my probate clients, is from that, because their loved ones earlier were clients of mine. Were satisfied with the work they received, and unfortunately, their other loved ones didn't have that same level of preparation. Didn't create that trust, and we end up in probate. So again, that's the majority of my probate matters, but I can help people, for lack of a better phrase, off the street with probate matters too. So we can get through it, but I think, and oftentimes, a lot of times when I do those probate cases, once they're done or during the pendency of them, the people who are receiving the proceeds are like, I don't want to have to go through this. When can I set up an appointment to create a trust? So it usually kind of ties back in with that as well.
There you go. As we're reaching the bottom of the hour, I do want to remind everybody this is a paid program. The advice and opinions expressed during the program are solely that of Melick Law, not necessarily WBEV or Good Karma Brands. I've discovered in my conversations with you that a lot of the misinformation that comes up regarding things like power of attorney, things like wills, trusts, estate planning, all that together is based on people making what they believe to be educated guesses, but they're really just assumptions, and assumptions that are oftentimes based on, nothing but the flimsiest thought or something they see on TV or a movie. Like we've talked before about the, if my kid gets hurt at school, they get rushed to a hospital, I could show up and just say, hey, my kid got rushed here. And they're like, oh, room 203, go.
Right.
It doesn't work like that at all.
Yeah, and to be clear, if the child's under 18, it works that way.
Right.
Right, but if the child is 18 and a senior in high school, it doesn't work that way.
Then you're suddenly in trouble.
That's when we need to have powers of attorney. Or if your student is off at college and they get hurt, then it doesn't work that way. Parents of children who are over the age of 18 have no ability to receive information, make decisions, or even find out issues of care and prognosis unless that 18-plus-year-old has a healthcare power of attorney in place. Same thing with spouses. Spouses don't automatically have that right. If I end up in a car accident, I'm taken to the hospital, I'm in a coma, if I don't have a healthcare power of attorney, my wife gets nothing. She doesn't get to talk to me. She doesn't get to talk to medical professionals. She doesn't get to review medical records. she's powerless.
Right.
That's why it's so important that everybody over the age of 18 have those powers of attorney as a starting point. I mean, we could talk about wills and trusts later, but as a bare minimum, I mean, every single one of us is one moment away from incapacity.
Right.
Now, the fortunate thing, unlike death, incapacity is not a given. In fact, most people will not be incapacitated, let's say, before the age of 50. Now, a lot of people get Alzheimer's or dementia at some point down the road. That's a different issue of incapacity.
Right.
But as far as what I call incapacity by accident, a car accident, a sudden stroke, most people are not in that situation until they're at least 50. And again, 50 is an arbitrary number. I'm just picking something off the top of my head. Whereas death, it's a much higher percentage. Certainly, the amount of people who are going to pass away before 50 is significantly higher, I'd argue, than the people who are going to be incapacitated by 50.
Right.
Because a lot of times those incidents they're sudden. Somebody passes away, they're gone. There was never a period under which they were incapacitated.
Right.
They get in a car accident, whatever the case is, or maybe they're incapacitated for a day and then they end up succumbing to their injuries anyway. So it's not a prolonged period of incapacity like you'd get with Alzheimer's or dementia. And especially nowadays, as people are living longer because of medical improvements in technology, a lot of times what happens is the body is in great shape, relatively speaking, but the mind is not. So that person could live years, if not decades, with dementia.
Right.
So that's a whole different analysis in terms of how long and what the scope of a power of attorney is going to be.
And I know when I was in getting looked at in the ER, even when they came in to tell me kind of my results and everything, they did have a brief moment where they just real quickly said, "And I assume you want your wife in the room for this."
Absolutely.
And in the back of my mind, I was like, "Well, of course she's my wife."
Right.
But then I thought back to our conversations, and it's like, no, they have a legal responsibility to make sure that they're covering all their bases, so that they don't have any liability.
Right. And take that a step further. I mean, as painful as your situation I'm sure was, let's say you didn't have capacity.
Right.
You were hooked up to a ventilator during that time. They couldn't even ask, do you want your wife in there? And she wouldn't be allowed in there anyway because you can't communicate your desire to say yes or no. So that's another issue. And to be clear, if somebody's in that situation and they don't lose capacity, certainly they can be asked and they can communicate. Now, TV gets a lot of stuff wrong, okay?
Right.
But one thing they do actually get right is the idea of nonverbal communication. I'm sure everyone's seen a TV show where someone's laying in a hospital bed, blink once if yes, blink two if no, or squeeze the hand once for yes, squeeze the hand two for no. That's perfectly legal because that is nonverbal communication. I mean, imagine this. Imagine if you couldn't talk one day, you had laryngitis, right? You could still communicate. You could write down what you want. You could do this. You can do that.
Right.
You can do this. You can do that. I mean, that's all nonverbal. That's the same thing as me saying yes. Me doing this is the same thing as me saying yes, right? So they actually get that part right. But the amount of errors on these TV shows is just, in movies, is just outrageous. I was talking on, I have another radio show on WISN. I was talking on that radio show last week about this. The TV show Suits. I don't know if you've seen Suits or I don't know if you followed it or whatever. I haven't seen the new ones yet, but it's about a corporate law firm, right? And it's obvious from the show that the producers of the show retain corporate New York lawyers or big city lawyers to talk about some of the nuances there. Because as a lawyer, it makes sense. That's exactly what they should do. But there are probably throughout the 10 seasons, and again, I don't keep track, but I'd say between 4 and 6 references to estate planning, and they're all terrible. So clearly they didn't decide to retain, or at least they're not consistent with Wisconsin law.
Right.
I guess it's possible because the show takes place in New York, even though it actually takes place in Toronto. It supposedly takes place in New York City. Maybe that's correct there, but I doubt it.
Right.
I think it's just the general, because it is just general prevailing knowledge. They talk about a reading of a will. I'm practicing law 18 years. I've never once read a will. It just doesn't happen. It's dramatic. It looks great on TV.
Yeah, it looks great.
But it doesn't happen that way. I mean, sure, you send out letters to beneficiaries, but there's never a situation where I've had 30 people gathered in my office and, you, Billy, get this, and you, Jane, get that. That's never happened.
Right.
So it's just, again, the misconceptions, again, in my position, I just laugh at them because they're so absurd and just geared toward Hollywood and geared toward trying to make people watch the show. Because again, I think I may have mentioned this to you. One of my good friends from law school is a criminal defense attorney in Manhattan. Okay,
Right.
And we were talking one time. It's like if you dropped an alien on this planet and you saw what I did for a living, you saw what he did for a living. There's no way you'd ever construe us both as being lawyers because our days today are so completely different.
Oh yeah.
Right? And again, what he does for a living is much more exciting. People can watch television shows about Law and Order or things like that. What I do for a living, nobody would watch it. It'd be done in 2 days. They give it one chance, they give it another, and then be like, this is terrible. We're never going to watch this anymore. But it's important, and it needs to get done. And you need to have the right people being able to help guide you in those decisions.
And I mean, it is so important that when you offer up the services you offer, you do kind of have different levels, because not everybody can come in and be like, hey, I need to do a full estate plan, I need to do a full trust, everything. Maybe they're not there yet, or maybe they don't have a need for that yet.
Right.
And so they might be able to come in and say, hey, can you just help me set up a will for now? Just the basic.
Exactly. Or even just basic powers of attorney. I mean, I'll give an example. I did an estate plan for a couple, probably, if I had to give or take guess, in their mid-50s. They had 3 adult children ranging between the ages of 20 and 26. And I explained to them about powers of attorney, and I ended up going to their house this weekend to sign estate planning documents for the 3 kids. I mean, these are kids; these are all adults, but same thing. Right. You know, one was away at college, one was, you know, just out of college, and the one was a little older. But the idea was, in all of those situations, if something happened to them, parents would not be able to make medical or financial decisions on their behalf unless we had the powers of attorney. So certainly those 3 people coming in are not going to need wills, let alone trusts, at that point in time. Their situation in life is powers of attorney. But those people, assuming they live, are going to get older, and their life situations are going to change. What if now they're married? What if now they have children? What if now if they have real estate? Those are life events that would necessitate the need for a will, or perhaps necessitate the need for a trust. And it's probably a good jumping off point. The next main life event, other than turning 18, in my experience, is having children. Why is having children the experience, aside from what having children does for you? And we can relate, we're both fathers here, right? Is the idea of an estate plan is the only way to determine guardianship of minor children, right? So the idea would be, if you have 2 parents and they both pass away, and these things do happen, right? I mean, they absolutely do happen. A court would determine guardianship of minor children. Again, if I bring this up in a social situation, people will say, well, I have a notarized letter that says my sister gets the kids, or I have a videotape that says they're going to my parents. My response as the lawyer is, that's great, completely unenforceable. Not worth the paper they're written on or the digital media on which they're contained. They are useless. It has to be in either a will or a trust. And again, what I would argue is, for my purposes, with my boys being 15 and 12, the most important thing an estate plan can do is determine guardianship of the minor children. The money, going through probate, the time, the aggravation, all pale in comparison to the decision that my wife and I would make for, if our children are in the unfortunate position of having lost their parents before the age of 18, who is going to be their guardian. There's literally nothing more important an estate plan can do for folks in that situation. Now, if you either don't have children, your kids are over 18, well, that's moot. But for folks in my situation, folks in your situation, having children under the age of 18, that is the most important thing an estate plan can do. And maybe a will accomplishes that. Then the next step would be from a will to a trust. What are we looking at there? The guarantee that the estate avoids probate. Because will-based plans, again, another big misconception. A lot of people think, if I create a will, I'm done, set it and forget it. To be clear, wills can avoid probate, but they're not guaranteed to avoid probate. And probate, again, is the process where a court oversees the administration of an estate. When an estate goes to probate, there are a series of hearings, series of filings, series of deadlines, series of events that occur before assets go from the name of the deceased to the name of the intended beneficiaries. I like to encourage my clients to create plans that are guaranteed to avoid probate. Not possibly going to avoid probate, not even highly likely to avoid probate. Guaranteed to avoid probate. The trust is the only guaranteed way to avoid probate. And when I explain that to some clients, they get skeptical or they have some questions. I boil it down to very simple terms. This may seem counterintuitive, but a well-drafted will should have as few assets as possible pass through it. What do you mean, Rob? What are you saying by that? Okay. So if I were forced to draft a will, okay, it would be divided 50-50 between my 2 kids. But what would I also do? I would list my kids as beneficiaries on as many assets as I possibly could. That way they avoid going through the will. They pass directly by beneficiary designation. Here's the problem, okay? Again, this is not the easiest thing to think about, but it's 100% true. There is no guarantee that either of my boys survive me. In fact, I will not know the answer to that question until the day I pass away. The trust, on the other hand, is 100% guaranteed to survive because the trust can't die. And I can build in provisions to the trust that I may or may not be able to do with certain assets by just listing direct beneficiaries. I'll give you an example. I am not aware of a single bank in the world, well, I shouldn't say the world, a bank in this state or that operates in the state that allows you to list multiple layers of beneficiaries. Okay. For example, I could go to the bank and I could list Grady and Hudson, my two boys, as 50-50 beneficiaries on my account. That I could do.
Right.
What I can't do is I can't say, okay, I'm going to list Grady and Hudson as 50-50 beneficiaries, but if one of them dies, I want the money going to my aunts and uncles. And if the other one dies, I want the money going to the Humane Society. They won't let me do that. Now, with certain other assets like IRAs and life insurance, they might. But with bank accounts, I can't. So if I list the trust, on the other hand, I can specify in the trust. If a person dies, it goes here. If a person dies, it goes there. And then what I also do is I list what I call an ultimate beneficiary. Okay. The example I give is this. We were talking off air that I'm leaving for a cruise on July 10th. Well, we leave Wisconsin on July 10th. The cruise leaves on July 11th. Okay. It's to celebrate my father-in-law who recently retired. So my father-in-law is having his two daughters, my wife and my sister-in-law, his three grandchildren, my two boys and my niece, along with his sons-in-law, myself, and his other daughter's husband, and his wife. So there's going to be 9 of us. We're going on a cruise.
Right.
What happens if the plane goes down? What happens if the cruise ship goes down? For his and his wife's estate plan, we build in ultimate beneficiaries. Now, in their case, they live in Maryland, so I couldn't help them. But I use that as an example of, because people say, well, what are the odds that's going to happen? I'm like, family vacations happen somewhat frequently. I mean, this is not an abnormal event to have everyone together. I mean, it's not something that happens every day, certainly, but it certainly happens once in a while.
It's definitely a non-zero chance.
Exactly. Yeah. And so having that document in place with the trust, it guarantees that you're going to have people receive it, whereas you can't do that with the will. There's no guarantee with the will. And if the total probate assets exceed 50 grand, it goes to probate, because there's certain assets that we can't list a beneficiary on. Things like vehicles, jewelry, appliances, tools, furniture, firearms, things of that nature. If those assets in the aggregate exceed $50,000, even if we do have alive beneficiaries that survive us, which there's no guarantee of, it still goes to probate because we're over 50 grand. So, and I don't think that's impossible either. I mean, I'd say most people in the listening audience, if you somehow magically were able to take every single item that you own in your home and put it in a warehouse, most people, the value of those items would exceed 50 grand, especially with vehicles. I mean, if you have your vehicle paid off, depending on how new it is, of course, you know, you're going to be in a situation where the vehicles alone may exceed $50,000. You have 2 vehicles that each exceed $25,000 in equity. That's not that unusual. No. It's certainly possible, let alone if you add all those other things in there, you know, especially here. A lot of people have firearms. A lot of people have boats. A lot of people have a lot of other toys, snowmobiles, ATVs, gators. I mean, all these things, extensive jewelry collections. You know, I have a client who has a baseball card collection that's valued at almost $250,000. I mean, I know that's an anomaly, but usually people have something that exceeds the normal value. Like the example I give is, I have baseball cards in my house, but they're nowhere near $250,000 worth of baseball cards, right? I may have some, you know, cheap artwork in my house from, you know, Walmart or Target. I don't have a Picasso, but some people do, right? I mean, there's any number of things that would cause people of, you know, extraordinary assets in terms of one field to exceed that $50,000 figure. Hummel figurines. I mean, Beanie Babies even. I mean, there's some Beanie Babies that are worth 5 figures.
Like some of them still hold their value.
Exactly. So it's any number of those things. And again, technically speaking, if those assets in total exceed 50 grand, it goes to probate anyway. Again, unless you have a trust. So the way I look at it is it's a guarantee. It's like insurance, right? And that's the analogy that I will draw for people quite a bit. If you own your home and you have a mortgage, you are required to maintain homeowners insurance. It is a condition, what they call a condition precedent. It's a necessary condition for the bank to lend you money to pay for your home. If you have a mortgage, they require you to have homeowners insurance. In fact, the mortgage documents often will what they call forced place insurance. So if somebody fails to get insurance on their home that's subject to a mortgage, the lending institution has the right to force place insurance at a significantly higher rate because they want to protect their investment. It makes sense, okay? What happens when you pay off that mortgage? You're not legally required to maintain homeowners insurance. See, it's different than auto insurance. Auto insurance, you're legally required. I mean, some people don't, but you're legally required to maintain automobile insurance in order to operate a vehicle in the state of Wisconsin.
Exactly.
Not the case with homeowners insurance. But I've yet to, in my 18 years of practice, meet somebody after I set it up this way who said, you know what? fast forward to the day or rewind to the day that you paid off your mortgage. I guarantee you nobody calls up the insurance company and says, you know what, cancel my homeowner's insurance. That would never happen.
Right.
Why? Because people want the certain outcome. But let's face it, I'm a big Brewer fan, right? Why do you think it's not Miller Park anymore and now it's American Family Field?
Exactly.
I guarantee it's not because AmFam is paying out more in claims than it's taking in premiums. In fact, it's the complete opposite.
Right.
It's a bad bet. Now, don't misunderstand me. I'm not saying cancel your homeowner's insurance. What I am saying is consider applying the same thought process of wanting the guaranteed outcome when you go through the analysis of a trust versus a will. Because yes, a will is going to be less expensive, clearly. It is less expensive to operate without insurance than it is to have insurance. The difference, again, between the will situation and the homeowner's insurance situation is if I maintain homeowner's insurance and I cancel it 1 year and I have my loss that year, I'm done. I still don't get it retroactively.
Right.
But with a trust, at least with my firm, you pay once and you get that probate guarantee for the rest of your life because, again, I don't charge for revisions to the documents.
That is absolutely awesome. And I mean, you touched on kind of an important thing there because I think about when we were renting before we bought our house, we had renter's insurance, which everybody should have.
Absolutely.
And even then, when it was, estimate the value of everything you have in your home.
Right.
And even then, with all the stuff we had, because I have a lot of collectibles, my wife had a lot of crafting stuff. We had already had 3 kids by that point. We've accumulated a lot of crap. And even then, we were like, we probably have about $50,000 worth of stuff.
Right.
So that was the policy we signed up for.
Right.
And, homeowners insurance, same thing, because now you're taking into account not only the whole value of the home, but everything that's inside of it.
Right.
And so it's really easy to look at those numbers and say, yeah, you're already at a point where with a will, you're already going to be looking at probate. You're already going to be looking at getting into trouble. And so getting to that trust is a good idea.
Right.
Now, that being said, you've said, if people start with one, they start with that will, and then they decide to move into that trust-based plan, they can do that with you.
Not only can they do it with me, they get a built-in credit. And that happens all the time. I have, what I call young families. They're concerned about guardianship. They want to make sure they as spouses can make medical and financial decisions, but maybe they don't have the means to create a trust at this point. Fine, they create a will. They pay X for the will. Well, down the road, they say to me, gee, Rob, now we're ready for the trust. I always tell my clients, my rates won't stay the same. They won't. Everything goes up, right? But what I would say is if you created the will with me for X, you'll get X dollars off the cost of a trust down the road. That way you're not double paying for services. So I call them built-in credits. And it's the same thing from power of attorney to will to trust. Same concept there, a built-in credit for the cost to offset it down the road.
Now, we've talked about how you will make changes if people need to make changes for stuff. Is there a limit to that? And I only say that because I know people who, they are getting remarried every couple of years.
Right.
Or, I have people that I know who they can't seem to hold on to a vehicle for more than a year.
Right.
They're constantly buying new ones, trading it in, doing whatever. Yeah. All things that could potentially be stuff that needs to be updated on their plan.
Yeah, no, I don't do that. But the first example you used was marriage. So the first thing there would be the new work of saying, okay, are we having a prenup? Are we not having a prenup? Are we having our children now being introduced in the mix, stepchildren, things like that. So there are portions of that would be considered new work, right? If let's say I did an estate plan for the wife, let's say, and now she gets married, well, does husband have estate planning documents? Right. Do we combine them? And again, if that was the case, whatever wife paid for hers, I would defray from the cost of doing theirs together. So that wouldn't necessarily be a revision. But for somebody whose marital status is not changing, I jokingly have clients who are past the Bill of Rights, right? The idea is the Bill of Rights is the first 10 amendments. Okay, I have clients who are beyond 10 amendments. So, it's one of those things where, most people don't revise their documents double-digit times, but most people do revise them at least once or twice, though. I will tell you that. And I'm not even that experienced, comparatively speaking, right? I've had my own law firm for 9 years. Well, if we're having this conversation 20 years from now, I guarantee you the percentage of my clients who've made changes is going to go up significantly. Right? Because there's just more entries into the possible pool, so to speak.
Now, it looks like we actually have somebody texting in, so we're going to go ahead and go to Jeff up in the studio. Jeff, what's the texter have for a question?
Good morning, everybody. Sherry would like to know if a person goes to the ER and has or does not have a power of attorney for health care, how do the people treating them know if they have one or not? People don't normally carry this document on them.
That's very true. My response to that would be the first step would be to make sure you have your healthcare power of attorney on file with your primary care physician. Because if it's on file with the primary care physician, that's usually the first call they make from the ER, is to try to identify the person, identify who their primary care physician is. So that's step one. Step two would be, if we get to that point, making sure that your loved ones know how to access the documents. In other words, if I do an estate plan for John and Jane Doe, let's say, and I give them an original and a copy set, I always encourage them to say, okay, make sure that your loved ones, your agents under the power of attorney, know where the copy set is. That way, if they get a call, hey, mom's in the hospital, they can go to mom's place, look in the third drawer of the armoire in the bedroom, get a copy of it, and then get it to the hospital. So that is what I recommend. The other thing is that a lot of times it's done systemically. In other words, there's Ascension, Aurora, Freighter, Dean, UW. There's a lot of systems out here, so that if you're admitted to one of those hospitals, they can cross-reference it and get an access to that power of attorney again if you have it on file with your primary care physician. So again, step one would be have it on file with your primary care physician. Step two would be make sure that your loved ones know how to access those documents in an emergency.
Now, would you ever recommend carrying a document like that on you if you are traveling, or if you're...
I mean, it seems a bit cumbersome. Right. I mean, again, I've never had that issue come up before. What I will say is this: I do represent a fair amount of people who have religious preferences such that they do carry their healthcare powers of attorney around with them. There's a pretty prominent sect of Christianity that does not allow for blood transfusions, okay? Oh. And they are instructed by their religious leaders to have their healthcare powers of attorney with them. And then they have a folded up version that they have so that they can let people know that, hey, it is their religious belief not to have blood transfusions. I mean, that's just one example, but right. That's a group that does have them there. So again, that's one possibility as well. But again, beyond that particular faith, I've never heard of people carrying their healthcare powers of attorney with them. One possibility, and I'm literally just thinking of this, would be it may not be a bad idea to have it on your phone. I mean, if you take pictures of it, at least in the interim, right, that may suffice. Again, I can't tell you what a hospital would say about that, and hospital A may take a position different than what hospital B is taking. I have no idea. Right. But those would be ways to kind of work around that problem.
Now, when I think about power of attorney, I'm always thinking about the, who gets to make those choices and those decisions for me. But it can also contain things like, care preferences.
Yes,
and things?
It can and should. So a lot of times what will happen is that'll be called what's called an advance directive or a living will, where right, you would specify, hey, I want my agents to be able to admit me to a nursing home. I want my agents to be able to decide to withhold or remove a feeding tube. I want my preferences known about being an organ donor. So I can tell you at my firm, I incorporate the who gets to make the decision in with the here are the answers to some specific questions the state of Wisconsin require, and just put them into one form. And then if you want to get more specific than that, there's a portion of the documents that I prepare that allow you to indicate special wishes, provisions, desires, things like that.
I did not know that. That's actually really good to know, because that can be a huge peace of mind for
sure,
a lot of people there too, because like you said, religious purposes, mm-hmm, or I personally know somebody whose mother had been very sick and in the hospital and had been on intubed for
yes,
a long time.
Intubated, yeah.
And there was a huge battle in that household about, was that mom's wishes, not mom's wishes, right, and there was a lot going on there. And so they have held very firmly to the stance of, if I ever get to that point,
right,
don't let me.
Right. And it's important to communicate those preferences to your loved ones and make sure it's consistent. Because, again, what I always tell my clients is this. In my experience, most overwhelming majority of people will follow the wishes of the person who is in that position. The problem is that 100% of those people are not mind readers. So if you don't express what your preferences are, they're just going to leave it up to guessing. And when there's guessing, that's when it's problematic. So as difficult as those conversations may be, I encourage my clients to have them with their loved ones, say, look, this is really what I want. And again, some people may look at that as morbid, but just as an example, and I may have told you this before, I've certainly expressed this on the radio program before, but I'm 43. I've already written my own obituary, because I have seen how obituaries can tear families apart.
Right.
Who gets included? Who writes it? What order do we put people in? What do we include? What do we exclude? Mine is written. My wife knows where it is. My paralegals know where it is. Right. If something happens to both of us, that part is taken out of the hands, even at my relatively young age, because right, I may die tomorrow. We don't know. But that's an example.
I mean, I guess it also gives you a chance to say some really nice, flattering things about yourself if you feel like it.
Well, and again, I mean, mine's very simple, but again, it's things I've chosen to put in, things I've chosen not to put in there.
There you go. And it's your directive. So
it is,
that's
and that's 100% right. In the tone of it too. I mean, I feel like a lot of obituaries are just very serious, very somber. Mine's pretty lighthearted. I mean,
that makes sense considering my conversations I've had with you.
You bet. And again, that's the thing. And my hypothetically adult children, my wife, they don't know what kind of tone I want in my obituary. I know what kind of tone I want. So that's what I've set into the obituary. It's not a Bob Uecker self-aggrandizing or that's not the word, self-deprecating. That's what I'm looking for. Self-deprecating thing. But it's things with a positive spin. It's not, the world is worse without him. There's nothing like that. It's one of those things where I'm just trying to say, okay, here are some positive things I've had in my life. Here's what I want remembered. Here's how I want you to remember me by.
Right.
Don't cry. Don't send donations. Send them to some charities. I've identified those charities. Things like that.
I like it. Well, unfortunately, we've reached the end of the show, so now the only thing I have for you to do is let everybody know how they can find you, where your locations are, the numbers they can call if they want to talk to you about getting their plan looked at or getting a new plan set up or even just sitting down to ask questions.
You bet. Best number to get a hold of me for any of my locations is 262-347-3444. Again, 262-347-3444. For most people in the listening and viewing audience, my closest location is Beaver Dam. I work out of the office that Sandy and Matt Heyer have, but I do also have locations in Saukville, West Bend, and Germantown. Free initial consultations, 20% discount for WBEV listeners. Willing to meet at any of those locations as well as virtually over Zoom, over telephone. Home visits. I do also make home calls as well for my clients who are maybe have mobility issues, maybe can't get a babysitter, don't want to get a babysitter, whatever the case is. So again, that's Rob Melick, Melick, melicklawwi.com is the website, and hope to hear from you guys.
Perfect. Well, Rob, always great having you on, and I always learn a little bit something new every single time, and I promise I will get in to see you at some point. It's going to happen.
I'll look forward to that.
It's going to happen. This has been a paid program. The advice and opinions expressed on the program are solely that of Melick Law, not necessarily WBEV or Good Karma Brands.